Hi all, thanks for joining my ninth session for Arbitration Boot Camp. I had 10 planned. My next one will be on September the 7th of next year, unless something crazy happens to my schedule. That will be called 10 Common Mistakes Made in Arbitration. And what I did was kind of cobble together on the back of a napkin some of the most common mistakes that I see and put them in one place. And it'll be kind of a culmination of a lot of things that I've covered in Arbitration Boot Camp. So I hope you'll find it useful. Today's session is on advocacy and arbitration. And what I'm going to try to do is focus on specific advocacy tips or pointers that relate to arbitrations alone. Of course, some of the advocacy that applies to the litigation context also works in arbitrations, but I'm going to try to focus strictly on some of the differences and the different advocacy opportunities that arbitration presents. So a lot of these will kind of be a review of the issues that have been raised in previous sessions and kind of put them all together. Most of this session is really all about changing the litigation mindset, which is a real challenge, I know, for counsel who are doing commercial arbitration, which is where I trained. And what I find is that many counsel who do commercial arbitration and then try their first arbitration have kind of an aha moment in which they realize the real opportunities that arbitration presents to both advocate the issues that your client wants raised, but also to do so in a way that achieves greater efficiencies and allows for greater creativity. So we start as a foundation principle that in order to really make the best of the advocacy opportunities, there's advanced preparation, and I'm going to talk about that in a moment, but also there's just a knowledge generally of the context. So for example, which procedural rules apply? These often allow for greater flexibility, and counsel should take advantage of that. What is the applicable law of evidence? And I've talked about some of the places where you can find the laws of evidence in the various statutes that apply across the country. And then it's really important to read the applicable rules and the legislation thoroughly at the very beginning of a matter. And that sounds like an obvious proposition, but it's surprising the number of times I've seen counsel and sometimes arbitrators as well debate an issue whose answer is actually found in the rules or the legislation. So this is a very good place to start. So my first issue that I'm going to talk about is what happens if there's no arbitration clause in the parties' agreement and you would like to suggest arbitration and persuade your opposing party that arbitration is the way to go. So the concern is always whether you can actually have a useful negotiation at a point in time when the parties have realize there's a dispute that cannot be resolved on their own, and sometimes they become intransigent in their positions, and that sometimes involves a reflexive response to the opposing party's suggestions or proposal, and that is no compromise. Anything the other side says is something that I won't agree to, and that does sometimes happen. So the question is, can you get the opposing party over that hurdle and get some kind of an agreement that will allow arbitration? And usually that involves persuading the other counsel. Now, if the other counsel is experienced with arbitration, it may be not difficult at all to persuade that counsel, who then may be prepared to try to persuade his or her client. But so that's your first advocacy exercise, is to try to persuade opposing counsel that arbitration will result in a more expedient and potentially less costly process. So there are some obstacles that inevitably arise when you're trying to make this proposal to the other side. And some of them can be overcome by some of the basic fundamental principles in arbitration law. So number one, if there's no arbitration agreement, use one of the institutional clauses that is tried and true and often very simple. And you see ICC sample clauses, ICDR, you see Faniak and Adric sample clauses, and they're great for their simplicity. But also, if you use something that's from one of the institutions, the opposing party and the opposing counsel will be less suspicious that you're creating something to try to gain an unfair advantage. So that can be a great approach. What if you've agreed generally on arbitration, but you can't agree on an arbitrator? You can avoid the court having to make that appointment if both parties would like to keep this process confidential, and agree to have an institution choose the arbitrator. It is possible to have the institution play this role, even if the parties don't want the institution to administer the arbitration. And some institutions, that can be quite a costly proposition, but many of them will serve as an appointing authority, even if they're not administering the arbitration. If you are then embarking upon appointing an arbitrator, the parties may agree that the arbitrator requires certain qualifications. So, for example, if this is a franchise dispute, you may wish to have an arbitrator who has some experience in that. And that is less dangerous to implement those qualifications at the point in time when a dispute has arisen than it can be while the parties are working well together and when they've included a arbitration agreement in their business contract, at which time you don't really have a sense necessarily of what potential disputes can arise. You can also agree that if there is some concern about the opposite party losing control over the choice of arbitrator, that the parties agree to interview candidates together. And I talked about how to properly conduct an interview of a potential arbitrator in one of my previous arbitration boot camp sessions. So these are suggestions that you may make to an opposing party that is reluctant to embark upon an arbitration process. Sometimes the opposing party or opposing counsel will lack experience in arbitration, and that is, I think, one of the most fundamental hurdles. And it's difficult to explain to somebody who has never experienced arbitration the real benefits, which are primarily creativity and flexibility in the process. And so it's very important that if you're going to establish a process, that you not simply use the rules of civil procedure, because they are a one-size-fits-all rule. And you've heard many times, I'm sure, arbitrators say that it is far more effective for a dispute to be resolved using arbitration designed rules. And the private and confidential aspect of arbitration may be attractive to the opposing party who has never experienced arbitration and may be sufficient for it. So I've given you a couple of ideas about how at the very outset as counsel you can use your advocacy skills to try to persuade a party to the process that you are advancing. What if the litigation has already started and you decide that it seems to be in party's best interest to arbitrate? And this is increasingly happen given the court backlogs that we are experiencing, which have been exacerbated as a result of COVID. Many counsels still don't think of the idea of moving the entire dispute or even just a part of it to arbitration. And when parties experience these court delays, it can be very difficult for parties to understand the alternatives, and it may be in one party's interest to actually take advantage of those delays. One party may want to move something forward quickly, and the other party may want it not to move at all. So that becomes a difficult negotiation, and particularly if one party is suspicious of arbitration. So it's possible, even in the middle of the dispute, to refer all of the dispute to an arbitration, no matter where you are in the process. It can be pre-discovery, or it can even be close to trial, when a lot of the matter is in play. When parties are interested in referring some of the issues, the idea is that you move the litigation along to a point where you're ready for trial and you kind of jump the queue, and you're not waiting for months to get an interlocutory motion date before a judge. The kinds of interlocutory motions that can be put before an arbitrator are limitless, but commonly undertakings and refusals motions, summary judgment motions, discovery plan motions. Those are the kind of motions that you can get an arbitrator up to speed and have a resolution of these issues move the case forward closer to trial in a very short period of time. And the motions themselves can in some cases be quite informal, but you can usually get a date quite quickly. The opposing party who may not be interested in complete referral to arbitration may agree to this kind of baby steps approach. And so if you are advocating for arbitration and can't get the other side to agree to it, refer the entire dispute, referring a part of the dispute may help you get there. There are efficiency benefits even if you're ready for trial, because you've got a plan, you've got the interlocutory motions addressed, and you have a better sense of what the other side's case will be when you go to trial than is often the case in litigation. So another issue that arises is how to persuade opposing counsel to arbitrate when the arbitration clause is bad. So this isn't necessarily, there is no arbitration clause, but the arbitration clause is bad. And as I dealt with in one of my boot camp sessions, a bad arbitration agreement is usually worse than no arbitration agreement at all, because it can create a lot of upfront disputes and therefore delays and costs. So if you end up with a bad arbitration clause, it's always open to you to say, you know what, now that I know what the dispute is, or because I don't want to deal with these upfront usually jurisdiction issues, I'm going to abandon arbitration at all. And maybe you can persuade the other side to move into the litigation forum. And maybe that works for this dispute. So notwithstanding that I've been advocating arbitration as a preferable procedure throughout my arbitration boot camp, there may be circumstances in which some of the jurisdictional issues seem to be overly complex or burdensome, and you decide, I want to get past that, and you choose litigation. Or you can choose perhaps Med-Arb, which some people call Need-Arb. So you have a process that involves a resolution, hopefully on consent, and if not, you move into an arbitration. You can see on one of my previous arbitration boot camp sessions, I think I divided into 2 sessions, all of the ways in which arbitration clauses can be bad, and some of them are ways that you may not have thought of. So if you're contemplating this, please go back to that boot camp and you may find some useful pointers there. I think the fact is that most parties will agree that litigating in 2 forums or arbitrating in 2 forums is not a great choice, but it may be all you have where you got a bad arbitration clause. These kinds of delays can be caused by a lack of clarity on who the proper parties are, or whether the scope of the arbitration falls within the current dispute, where you can't agree on an arbitrator because the arbitration clause doesn't provide for the appointment or creates difficult obstacles to overcome before an arbitrator can be appointed. Or if the arbitration clause doesn't set out the rules to be followed and one party isn't prepared to simply agree on rules or let the arbitrator decide on an ad hoc basis. If both parties are committed to arbitration, there's a presumption that you will have little difficulty in overcoming even a bad arbitration clause. What to do if your client really wants arbitration instead of deciding that perhaps litigation in the courts will end up being an easier or simpler approach. You can have some assistance in getting an arbitrator appointed, and maybe you know somebody who is by reputation great at a case management type process, and that may very well entice the other party to participate. You can also use leverage if you're trying to persuade a party to choose arbitration. There are some parties that will want privacy, and if there's some concern about disclosure, public disclosure of some of the facts or evidence, you may be able to persuade the opposing party to choose arbitration simply for that reason. Another reason may be that party that the arbitration clause, for example, is clear that no appeals are permitted, and obviously if the parties move into a litigation forum, that creates a potential for public disclosure of some of the or all of the dispute. So that can be a very persuasive way to tell the other opposing party that arbitration is beneficial. There may also be some urgency to the matter, and perhaps an interlocutory injunction or interim measure in arbitration lingo may be something being contemplated by one of the parties. And if you can persuade the opposing party that you can get an arbitration completed fairly quickly, that may avoid the delay and costs associated with interim measures. And there are all sorts of ways to pitch the idea. There are very, very efficient arbitration processes like baseball arbitration, where the arbitrator hears the evidence and must decide between one of two, if there are two parties, offers essentially without reasons. And that can be an effective process. Abbreviated reasons, asking the arbitrator not to provide detailed reasons because there's often some delay in getting reasons. The only caveat I would put on that choice is something that I referred to in one of the arbitration boot camp sessions. And that is that by requesting abbreviated reasons from an arbitrator, you likely make it more difficult to achieve an appeal or a set-aside application. The other way to persuade the other side about arbitration is just simply to tell them about the benefits. And if you tell them about the benefits, then your best advocacy approach is actually to make use of them. So the theory of your case should be developed comprehensively from the beginning. I find that litigation is often a series of surprises that emerge when you get the client's documents, then you get the opposing party's documents, then you participate in examinations for discovery. And because it's a gradual discovery process, you often don't really know the evidence that's going to help your case or hurt it, or even who the proper and appropriate witnesses are until quite far into the process. And arbitration, when done differently, can provide all of this information up front. So if you choose that process, the best advocacy approach you can take is to learn your case up front and do all investigations very early on. And I'm going to come to this in a moment, but all of this, of course, is with a view to being fully prepared for the first procedural conference, where you will have an opportunity to try to persuade the arbitrator that the process that you think will advantage your client is the one that should be pursued. So front-ending your case, as I call it, requires significant preparation. So what is your story? What are the gaps in your story, and how are you going to fill them? What are the bad parts of your case, and how will you overcome or explain them? Don't leave this to final preparation. This is something that you can do very early on in the case if you have done upfront preparation. Strategic thinking starts early in arbitration. There may be no discovery at all. There may be no production, and there may be no oral discovery. If there's no documentary production, that may be because the parties have agreed to the process that I discussed in a previous boot camp, that the evidence goes in, excuse me, by way of affidavit, and the affidavit encloses all of the documents that that party intends to rely upon. That's it. No further production unless the opposing party is seeking additional documents or information. And there's no discovery because you have oral discovery, because you have the other side's case in affidavit form, and you then have an opportunity to cross-examine that witness in the arbitration hearing itself. So this is another reason why upfront preparation is key, because you're going to have to put in your evidence in chief, which is the witness statement or affidavit, very early on in the case. And that upfront preparation then creates efficiencies later on. Your cross-examination is much more thorough because you've got a high level of preparation, and you haven't gone through the whole discovery process, which is the most lengthy and expensive process in courtroom litigation. Another difference between court litigation and arbitrations that you can exploit for the purposes of persuasion is what I'm going to call the pleadings, because that's not really a term known in the arbitration world, but if I use that word, you understand what I'm talking about. And the pleadings are not limited to facts. You can include law and argument in a pleading as well as key documents. So that is perhaps your first opportunity to advocate your case to the arbitrator and, of course, to the opposing party. The first procedural meeting is your next opportunity. And that's your opportunity, of course, to try to persuade the arbitrator and the opposing party that your vision of how the case should unfold is the one that meets the requirements of allowing the parties to each of the parties to meet the case they have to meet and to set out their case. So preparation again is key. Consultation with the opposing party is expected. It is very common that the arbitrator's terms of appointment or the first procedural order will say it is expected that the parties will consult with one another to try to resolve issues before they come to the arbitrator. And I find that a very significant term because in my experience in courtroom litigation, it's very, very common that parties will get involved in motions and never actually pick up the phone and talk to one another about a potential resolution. And that is something that happens all the time in arbitration. Strategic decisions on process are informed by the preparation that's been done up front. So you must know all about your case at the very beginning, and at the first procedural meeting, you must be prepared to lay out how it's going to proceed all the way through to the final hearing. And it's very common in arbitrations that you actually set a date for all of those procedural steps, including the final hearing date, and that those dates stay unless there are unexpected circumstances that will result in either an agreement or a decision by the arbitrator to change those dates. And the whole purpose of arbitration is to make sure there isn't the kind of same drift that you see quite frequently in courtroom litigation. So make sure, of course, at your first procedural meeting that you understand the legislation and you understand the rules, so you understand the framework in which this case is being decided. Most arbitrators will send an agenda or a list of items to be discussed at the first procedural meeting. Take advantage of those agenda items to assist in your thinking and, of course, in your discussions with opposing counsel. And most of those agenda items will, of course, deal with the steps in the arbitration. And the arbitrator may know very little about the case when that agenda is set out. So make sure that if you have any additional items that ought to be discussed, which advance your client's interest, you raise them at the first procedural meeting. The other very effective advocacy point is to make sure that the arbitrator understands that you know your case. So you are creating credibility with the arbitrator if you are prepared, know your case up front, and you also know the process that you think is going to move the case towards a hearing in the most expeditious and cost-effective way. You want to be the one that the arbitrator relies upon for guidance going forward, and therefore you really do need to present a reasonable front. There are issues, of course, that relate to process. Some cases are what I call kind of one-sided or asymmetrical. And that means that it's sometimes the case that only one party really has the key documents or the key evidence. This is sometimes the case where, for example, there's a negotiation of a contract and for example, an employment agreement, and maybe only the employer has some of the key documents. The employee may only have the evidence about the employment history and how the termination took place, but the employer may have all the relevant documents, policies, procedures, stuff, etc., relating to the expectations of employees and the procedures for termination. So if that's important to allow in this case, employee to prepare, raise that issue up front in the first procedural meeting to ensure that the party without the information has sufficient information quickly so that the witness statements, etc., can be prepared early on with all of the information. Customization of the process is absolutely critical, and it takes place at the first procedural meeting. Do you need a hearing at all? That's one of the most important issues that an arbitrator will raise often at the first procedural meeting. One of the ways to shortcut some of the process is to agree on a written hearing. If a party, under the legislation and under the rules, if a party wants an oral hearing, the arbitrator must give it. But it is really worthwhile giving serious thought to whether the matter can be resolved in writing. And that is often the case where there are no issues of credibility, or there are separate issues that are to be decided under different terms of the contract, for example. But it is an extremely efficient and fast way to have all the issues decided. You can still put in your evidence, you put in your argument, all of it's done in writing. The case management process will often provide for motions and interlocutory disputes to be dealt with very quickly without the formality of a motion record or a hearing. And so if that's something you think benefits your client, you can always raise this at the first procedural meeting, that you would prefer that motions get dealt with informally, sometimes by email and often by Zoom. And if you are counsel for a party and there's a 3-member tribunal deciding the case, it's not uncommon that parties will agree that some of the interlocutory motions can be dealt with by the chair of the committee. And this facilitates having an early hearing, because you're only worrying about one schedule, or as many schedules as is the number of parties and the arbitrator, and you don't have to worry about deliberations and those kinds of delays, which is a real benefit in order to keep things moving forward in a way that doesn't risk losing some of the steps that are written in stone about how the arbitration is going to go and the various deadlines. The rules of evidence, again, do not apply in arbitrations, and I dealt with that in a whole section. So this gives you a lot more opportunity for creativity in your advocacy. You can make liberal use of charts and graphs. Hearsay is offered more readily. The real issue is not whether the evidence will be admitted, but usually a matter of weight. And so I think this gives counsel a lot more creativity in making their case to the arbitrator. Take advantage of that. The arbitration process also provides more opportunities for early written advocacy. Again, I've talked about the pleadings, which may allow for argument, incredibly useful when you want the arbitrator to understand not only the key facts, but the real issues at play and the parties' different perspectives on those issues very early on. And that, of course, is helpful when you get to, for example, document production disputes or other kinds of interlocutory disputes. When your decision maker has a better sense of the overview of the case, you're going to be more comfortable with the decisions. Again, sworn witness statements up front very early on in the case allows for, in most cases, that evidence to go in chief, and cross-examinations take place at the hearing. One cautionary note: there is a real temptation, and I hear about it a lot from our arbitrators, to use the affidavits as an opportunity for advocacy. That is not their purpose, and it undermines the credibility of the affidavits. The affidavits should contain no argument. That's for your legal submissions. And the affidavit should sound like the witness's evidence. This sounds like an obvious proposition, but sometimes the affidavits read like lawyer affidavits, and that does undermine the credibility of your evidence and the credibility of your case. So the affidavit needs to sound like the witness. Openings and closing. There's a lot of debate whether they should be both written and oral. Again, this is something that you need to decide whether the costs justify it, whether you think it would be useful for the arbitrator to have both oral and written submissions. I think that written submissions are undebatably important, so that when the arbitrator or tribunal goes away to consider it and deliberate, they have your submissions in written form. Sometimes, however, counsel would like to have the opportunity to face the arbitrator after the evidence has gone in and provide an opportunity for the arbitration tribunal or the arbitrator to ask questions. That can be very useful as well. That should be something that is decided at the first procedural meeting. That sort of thing may be subject to change as the time goes on, but many counsel have very strict views about what they prefer, and the case may demand a specific position with respect to openings and closings. Another issue that is unique to arbitration is the various ways that expert evidence can go in. Use those to your advantage. Expert reports often go in quite early, not necessarily with the witness statements, but they're quite shortly thereafter. That allows the opportunity of the witness to understand what the facts are in the case, and also eliminates the late expert report delivery, which we see so often in litigation, because of the rule that provides that findings, opinions, and conclusions of an expert must be disclosed unless the party undertakes not to call that witness at trial. That, of course, creates concerns at pretrial conferences because expert reports haven't been exchanged, and it really affects the ability of the parties and the tribunal to prepare for what can, in some cases, be the most important evidence in the case. So, early expert reports. There's also flexibility in how those expert reports go in. Will they go in separately? Will the experts meet together and prepare a third report in which they identify the differences in opinion and where they agree and the reasons for that? Will the experts testify in a panel, or what we call hot tubbing, where there's an opportunity for them to testify together and allows questions from counsel and from the arbitral tribunal, which both of them can answer in order to allow the tribunal to get a better understanding of, in some cases, why the expert reports are so different. It can be very, very useful. And there's a Chartered Institute protocol or guideline on the best way to have experts testify to kind of achieve those kinds of efficiencies and to assist the tribunal in understanding what their evidence is. I guess the most important point is that you want to maintain as counsel the most control over the process as you can possibly achieve. And again, preparation is key. You can only take control when you know what you're trying to achieve. You will have more opportunities to communicate with opposing counsel. Use those opportunities to your advantage. The arbitrator will expect that counsel have communicated with another. Consider very early on, what disputes do you think are likely to arise, and can you manage them up front, anticipating them up front? If you are fully prepared, that may give you an advantage over your opponent. Can you use an agreed statement of facts? My experience, to be perfectly blunt, in litigation is that it is often a difficult, time-consuming process that rarely yields the kind of results that the rules contemplate. But in the arbitration process, it may be that you can achieve better results and focus the case so that there are fewer issues to decide. After the affidavits have gone in, it may be easier for the parties and counsel to agree what is in dispute and what is not in dispute. Be proactive on scheduling so that the schedule doesn't slide when there are issues that the parties frankly don't anticipate, and you end up having a hearing take place much later or over piecemeal on several days that aren't consecutive, which can affect preparation, cost, etc., etc. So knowing your case helps you with the scheduling, helps you persuade the arbitrator that the timelines that you're talking about are doable, and then also creates an obligation on the part of the parties to maintain those schedules, those timelines in the schedule, because that's what the arbitrator is expecting. So in a sense, you're supervised in a way that the courts don't do. Another part of advocacy is preparing or managing your client. Clients that are used to court proceedings may have expectations about how those court proceedings are going to go, and the fact that this is going to be a long process and they need to budget throughout say a 5-year period. Make sure the clients understand that this is a more cooperative process so that they don't think that you're not as aggressive as they hope you'll be, and that's a characteristic that's common in litigation. Make sure that they understand that that's not the process that wins the day in arbitration, and that deliberately obstructive behavior will not be acceptable. And part of the reason for that is you've got the same arbitrator through the whole process, who can see who case manages and sees whether there are parties who are playing games. Manage the client's expectations, because there will be greater upfront costs than a client is used to. And that is the first procedural meeting, preparing the pleadings in a way that is much more detailed. And of course, putting in the affidavits very early on. So the client will have to budget in a different way. The importance of having the client understand the process cannot be understated. A more informed client will give you better instructions and will understand the process and use it to that client's advantage. So the next is know your arbitrator. Have you taken advantage of the opportunity to select an arbitrator who is experienced and who subscribes to this case management approach? This is an arbitrator who will help you achieve the objectives that you are trying to achieve. Most parties arbitrate because they are hoping for a different process than court litigation. So make sure that you are able to choose an arbitrator who advances those objectives. Again, part of your advocacy role. That involves doing some due diligence on the arbitrator. How does the arbitrator approach a case? How does the arbitrator conduct a hearing? What has the arbitrator published, which gives you a sense of the arbitrator's philosophy? All of those can be dealt with in a meeting if that is possible. But otherwise, there's lots of information to find out about arbitrators' reputation, things they've published. So part of your advocacy is making sure that you've chosen an arbitrator that is going to advance the objectives that you find important. I think the most important point about advocacy and arbitration is to accept a different mindset. All of the points that I've talked about are examples of ways you can try to do the arbitration differently than you do in courtroom litigation, because that's what the parties want. As a respondent, you cannot use the same delay tactics as you use in litigation, and that may be a reason why a respondent doesn't want arbitration. But once you're in it, you can take advantage of the opportunities for finality. Many respondents also want that. If the matter has to go ahead, they want to know that it can be dealt with quickly. The arbitrator's job is to manage the process and to make sure it moves forward. So don't be surprised by that, and don't let the arbitrator drag you along. Stay ahead of it and make sure that you are proactive about the process that you want and the important issues that have to be resolved. This requires attention to detail very early on. It requires a creative approach because, again, the process may not be the one that you used in your last arbitration, and it may not be the one that you use in courtroom litigation. What is the best way to achieve the outcome that your client wants in this dispute? Be familiar with all of the legislation and the rules. And essentially, the rules, the fundamental rule is that all parties must be treated equally and each party shall be given an opportunity to present their case. That's the foundational principle. And you can use that to customize a process that works for you. There are some processes from the rules of civil procedure that can be eliminated, and that does not mean that you are sacrificing the fairness of the process. Use that to your advantage. And as I said before, oral hearing is required if a party requests it, but think about whether it's absolutely necessary. As an advocate, do not let somebody else drive the process. You have more control in arbitration than you do in litigation. You need to decide what is the end game and how do you get there. You have a lot more tools in your arbitration tool belt than you do in litigation. So I actually don't have my Q&A box on. I will put it on right now. I see that there are no open questions. I'll give it a few moments to wait for questions. But in the meantime, just a reminder that the next session is September 7th, 12 to 1. It's my last session. I did plan 10 sessions, but I am open to future sessions if there is a request for me to deal with a specific issue. I chose 10 because, to be honest, when I was sitting down planning these, I thought of a lot of the issues and it happen to number 10. So if you can think of something that I haven't thought of, then I'd be glad to host a further session. If you want to send me your feedback, I'd be glad to hear that as well. I don't see any open questions. So we're actually finished a little early today. I'm finished as well. Have a great day.